Welcome everybody to Law&Crime Daily. I'm Jesse Weber. That 70s show star Danny Masterson learned his fate in a Southern California courtroom Thursday after being convicted of raping two women, 30 years to life in prison. Masterson did not speak during the sentencing, but Masterson's two victims did, and a statement from a third woman who made allegations against Masterson was also included. Masterson was found guilty of 2 counts of rape back in May. He was first tried last fall, but jurors couldn't come to an agreement about what happened in the actor's Hollywood Hills home between 2001 and 2003. Multiple victims claimed that Masterson drugged and raped them. Prosecutors vowed to bring charges a second time, and a retrial got underway in the spring. But this time around, the judge allowed the witnesses to say that they were drugged despite no forensic evidence of drugs being presented, and the Church of Scientology featured more heavily in the retrial. It took the jury 7 days of deliberations to reach their decision. Masterson's accusers are also suing him and the church in civil court. Now, during the sentencing, the judge had this to say, quote, "Mr. Masterson, you are not the victim here. Your actions 20 years ago took away another person's choice and voice. Your actions 20 years ago were criminal, and that is why you are here now." Let me bring in my top-notch legal analyst, co-host, Terry Austin, Brian Buckmeyer. Good to see you here. So I don't know who I want to start with first. I'll start with you, Terry. So you think about it, the victim impact statements. I wonder if that had an effect, because sometimes we go into them saying the judge already knows what the sentence is going to be. However, do you think the victim impact statements create an impact on it?
Well, I do think they had some impact. I do believe this judge had already made up their minds. I mean, here we have someone who got the book thrown at him. 30 years was the maximum. So if you think about it, when you're going to write up a sentence and you're going to say something, you've already planned that all out. You know, it's written, you're reading it, and you've already thought about what you're going to say. One of the things here was that he did change the lives of these women, and that there's no remorse, and that he's sitting there and he's thinking probably that the system has done him wrong.
And it's also consecutive, right?
It is, yes.
Explain why that's a big.
Well, I think the issue was it's different women, and so the judge wanted to make sure that each of them has their ability to have some sort of, consolation here, that he is serving time for their crime that was committed against them. But I think, to answer your question, the judge already knew, but because there was no remorse and because he sat there thinking that he had every right to do what he did, the victim impact statements made a difference.
Masterson didn't say anything. Was that strategic?
I think so, because it's 30 years, but it's 30 years to life. So after 30 years, he has a possibility to go to parole board. Taking ownership for what you've been convicted of is one of the factors the parole boards really think about, and that could have helped him got out when he's, 77 years old, and his 9-year-old daughter is then 39, probably something he wants to get out. I think it might be strategic in the sense of the appeal. When we saw that first trial, the majority of the jurors were going towards an acquittal. And then facts like you pointed out about the ability to say that they were intoxicated, even though no forensics to back it up. And even some of the other testimony from uncharged witnesses came in. I think it's a very elementary appeal, just in the sense that you could say, Judge, no conviction here, leaning towards innocence, conviction here, look at what changed, we want an appeal, this was wrong. I think that's why he stayed silent.
Okay, so there might be developments down the line, but right now, what a major sentence for Danny Masterson. And welcome back to Law&Crime Daily, everybody. So the defense team for alleged killer Bryan Kohberger says that instead of cross-examining a witness during a recent hearing, Idaho prosecutors sent the FBI to her house to do it for them. Gabriela Vargas testified during a hearing about DNA testing and genetic genealogy last month. Kohberger's attorneys say that only a few days later, FBI agents came to her door and interrogated her about her testimony. Prosecutor Bill Thompson said that investigators had heard through some of Vargas's colleagues that she was going back on some of the things she testified to in court. And evidently, Vargas may have signed a written declaration as to what she was testifying to without fully reading it. Police in Moscow, Idaho say that Bryan Kohberger entered a rented home near the University of Idaho last November and stabbed 4 college students to death. Kaylee Gonçalves, Madison Mogan, Zana Kernodle, Ethan Chapin. They all died from their wounds. Now, Kohberger was a doctoral student nearby Washington State University. Police collected trash from Kohberger's parents' home in Pennsylvania, where he was spending Christmas break, and used a DNA sample to link him to the sheath of a knife found in one of the bedrooms. Here's some of what Gabriela Vargas had to say about her involvement in the process during that August hearing.
I was contacted by defense. Well, I take that back. I was contacted by somebody in this field. I don't know if I could say who it was or if it's relevant. Asking if I would be willing to talk to the defense, and I agreed, and I had that. It was a Zoom call in which I was asked basically just to explain the process in which I go through from start to finish on a case. So what is, from when law enforcement contacts me to when I provide the investigative lead back to law enforcement, what is the process? And that was the extent of my involvement at the time. In the end, what I provide to law enforcement is an investigative lead, and it is up to the agency to then take over their case and confirm that my lead is in fact correct.
So let's be clear, Terry. The parties, they're allowed to speak to a witness, right? But what makes this a bit unusual?
I actually went over the American Bar Association code to see what the parties can do when they are investigating and interviewing witnesses. And both sides can interview all of the witnesses that they know about, even if it's a witness that will be called from the opposite team. But here, what's very different is the FBI win. And that's a little odd. I mean, the prosecution wanted to follow up. That makes sense. If there is a change in the genealogist's testimony, why not go and find out what exactly is that change? But usually you send one of the lawyers, one of the paralegals, one of the investigators. You don't really send the FBI. So I think that's what's unusual here. I mean, you have investigators who do this for a living, who work for the prosecutorial team or for the defense team. It's just a little odd, and it is intimidating to have the FBI come to her home. And so I think there's a claim here on the defense side that, she was intimidated, that maybe she was trying to change her testimony, and the FBI might have pushed her in that direction.
Well, that's what I was going to ask you, Brian. Does the defense have an argument to either the judge or the jury at a trial about the way this witness was questioned by the FBI?
I don't think they have an argument with the judge because, to Terry's point, while we may call them the prosecution's witness or the defense's witness because they testify on their behalf, you don't actually own a witness. I've actually done this in trials before. Prosecutor says they're about to call someone on a witness list that I haven't spoken to before because it's some family member who saw some random event at a party that they're going to try to use against my client. I'll slide right into that room when no one's in there and ask them a bunch of questions. And if a prosecutor wants to come and knock on the door and say, hey, that's my witness, I said, I don't see your name on this person. I can ask whoever I want of any questions. But just as we were all a little skeptical and it's a little bit unusual, we could present it to the jury and say, isn't this a little weird? Why would you do this? What if you testified, you being the jury, testified one way about something and then the FBI came to your door? How would you testify then? And I think that is a bit of a seed, even though you can't go all the way and say this is jury tampering or witness tampering, but it's enough of a seed to raise a little bit of doubt potential.
And real quick, they can ask that question in front of the jury about the FBI questioning her.
Why not?
Yeah.
Okay. Well, that'll be interesting when we have a trial, whenever that happens.